Generally, a corporation isn't bound by contracts that are entered into on its behalf by a promoter. That is, a person who takes the steps to form the corporation before the corporation's existence. However, a corporation may be liable for a preincorporation contract entered into on its behalf by a promoter if the contract is adopted or accepted by the corporation after its organization. In McArthur v. Times Printing Company, the Minnesota Supreme Court considered whether a corporation, based on its corporate officers' and directors' actions, adopted or accepted a contract made on its behalf by a promoter before the corporation was organized. In the late 1880s, A Nimocks was a promoter who was helping to organize the Times Printing Company, a newspaper publisher, which we'll call Times. On September 12, 1889, Nimocks, as a promoter, entered into an employment contract with McArthur on behalf of Times. Under the contract, McArthur was to work as an advertising solicitor for a one-year term, starting on October 1st, which was Times's expected organization date. However, Times wasn't organized until October 16th. At the time of organization, all of Times's stockholders, directors, and officers knew of McArthur's contract. Nevertheless, Times's board of directors never formally adopted or accepted the agreement, but none objected to it, and they continued to retain McArthur. On April 1, 1890, McArthur was fired from his position at Times, which was 6 months before his contract was supposed to expire. Subsequently, McArthur sued Times for breach of contract in state district court seeking damages. The case proceeded to a jury trial, and the jury found in favor of McArthur. The court then entered judgment on the jury's verdict. Times appealed to the Minnesota Supreme Court.